Hey, Carlos. Nice to see you. Always happy to chat with you. And excited to add another version on our YouTube channel for the Self-Storage Legal Network Legal Chat. So I know you've been thinking long and hard about all the important topics in our industry these days and have decided to lead the way with a hot topic.
Well, my mind is taking the turn to technology and how that's having an impact on our industry and perhaps on litigation. So I've got a question for you, and the industry has really ramped up its rental of spaces and just doing things on their websites with respect to their customers, and its primary place where they post their offers and actually go as far as renting the storage units. And my question for you is, based on some of the things I've seen, are these websites litigation landmines? Because we see ADA lawsuits, we see wiretapping lawsuits, whatever that is, and drip pricing is something that's in the news today. And we even have, these ideas that, well, the website are engaged in deceptive trade practices. And I just wondered what you think about all of this.
I think you're scaring all of those operators out there in the world that are working so hard to enhance their business through advances in technology. I will admit, I miss the old days where a tenant would walk into a facility, choose to rent a unit. The manager would take out of their desk drawer a nice written 3-part contract for them to sign, and everything would be hunky-dory with the execution of the document, which would be, carefully placed in a file folder in a closed drawer. We've come a long way. But, look, we had lawsuits about deceptive trade practices and violations of privacy and misleading issues when contracts were in writing in the office. So this is probably nothing new. And we can, let's kind of address one at a time.
Well, I think the oldest or the sort of the early stages was the ADA lawsuits that were, basically complaints that the website wasn't really accessible by the visually impaired, and in some instances, people with hearing impairment couldn't access certain parts of of what was taking place on the website, and this was a violation of ADA.
Yeah, so if you look at the ADA as a situation where we're protecting those that are covered under the disability laws as any obstacle to being a customer at a facility, certainly when it was created, I think the concept was physical barriers to access. Now we've moved into the virtual, intangible method of access. And the question is are these websites accessible to those visually impaired or hearing impaired? I know that the circuits are split on this question. There's been a case law decision that would find that the ADA requirements do not comply when it's not a brick and mortar business. But I think you and I both agree that we tend to lean towards the problem solving that enhances the rental opportunities for all tenants. And those operators that have created solutions to this ADA claim by adding screen readers to their websites as part of their development has been the easiest and best solution to that ADA claim. Do you think that's the fair way to approach it?
I agree with you 100% on that issue. And again, I think that the problem is for the visually impaired more than the hearing impaired and other users because of just the nature of the way that websites are used. But I do have a bit of good news. It's usually not good to find out that the federal government has engaged in regulation or developing new regulations, but that has been a complaint in the ADA area for quite a long time. There were no standards, and it's my understanding that they have finally adopted the Web Content Access Guidelines 2.1 as the standard that you're supposedly should comply with at this point in time. And that was I think that just happened sometime this year.
And under 2.1, does it have the screen reader?
Yeah. That was a very early part of that, and again, I think the vulnerability, because when you get into hearing impaired, it usually has to do with websites that have video content. And the closed captioning kind of thing that is necessary with that. But again, I just recently read about it, so it's really at least for me, and I'd kind of look every now and then because I was curious about it, because there was quite with business community in general, we have no regulations, we have no guidance.
Yeah, so I think that's great clarity on that question, and I think that it's important for operators to regularly have their websites audited for ADA compliance, because under this 2.1 content guidelines, they outline issues concerning font size, color, just mentioned like closed caption on video. That can really provide some guidance, and operators need to rely on their web developers to maintain their websites in compliance with that regulation. So I think that's a great guide tool for you to mention to operators that they can look to that and convince their developers to look at that and get them covered. Look, I have found that no matter what an operator does, they'll never be 100% compliant, unfortunately, and that does create an avenue for potential claims and remedies by ADA proponents and plaintiffs' lawyers that bring these claims. So I don't think anything we can do to avoid the risk of liability in ADA online website litigation.
No, I think you're right, but I have seen, because over the last few years, there seems to be not quite the volume of these lawsuits as there had been in the past, and obviously part of it is because operators, self-storage operators, and other businesses have adapted to the WCAG requirements essentially, and are complying with those guidelines now. And I think, as you indicated, the vendors who provide the websites or maintain the websites are also aware of these regulations.
So what about deceptive trade practices and now our world of drip pricing?
Well, I'm going to tell you that there was the deceptive trade practices has gotten a bit scary in my mind. We keep coming back to that concept. We get do be afraid, but there was recently, and I mean we're very recently, I think it was last month, a lawsuit against Public Storage. And what was really interesting were the two classes, and that they were proposing, because what one was sort of ordinary in that they had alleged that PS had not disclosed its admin fee, and if you go to the PS site, it clearly discloses in a banner along the top its admin fee. Now, there's always lag time, and these events supposedly occurred the middle of last year, so there may have been that issue involved. But the other proposed class was even more frightening, because it was all tenants who had rented a space whose rent was increased. Full stop. I mean, can you imagine that they never disclosed on the website that they could increase the rent, and that failure to disclose meant the rent that was being charged was the rent that should be charged forever?
Well, I'm very clear that their contract includes a changes provision which gives them the right to increase the rent. I have to believe that those contracts were executed against the tenants who claim to be part of the class. It can't just be the people that went on the website and
No, it was people who were tenants, but they said that the rental agreement didn't matter because they failed to disclose it on the website.
that, well, we'll leave that to the great minds of the law to figure that one out. I think what you're saying though is that people have to be very careful about what they put on their websites to make sure that they don't fall prey to claims with regard to misleading advertising. So I think you'd agree with me the phrase "more is better" would apply to website disclosures.
Well, there may be a simpler solution, and it's one that Public Storage, we don't know how the courts are going to respond to it, but Public Storage, if you look at their documentation, they have mandatory individual arbitration provision in their terms of use, and they have a similar provision in their rental agreement. Now, given their size, obviously, mandatory arbitration is going to be something they're going to have because they're a target for class action lawsuits. And the real power of that mandatory individual arbitration is it can basically put a stop to class action lawsuit in its tracks.
Well, on the other side, we've all talked about the world of mass arbitrations and how that can affect business operators where these claims are sought to be converted to arbitration, but then individual arbitrations can be filed in the tens of thousands.
Hard to do in self-storage. Unlike employment, there's no interrelationship between the various parties. One tenant, isn't going to know 10 other tenants, where if you're in a workplace, that's a different, we haven't really seen that go beyond, in my mind, this, mass arbitration beyond the work, where it really has been a problem, especially in California, because it not only does it create problems in and of itself, pretty much the entire cost of mass arbitration falls upon the employer. And but I haven't seen it in just sort of random groups, like all Amazon customers have never kind of individually got together and tried to sue Amazon. But I'm open to the idea that it could happen.
So in terms of practice pointers, when you see these cases and think about the pressure on operators that we know and love in the self-storage industry, recommendations with regard to their websites, I guess I'm hearing you say that they should also update their terms of use of the website to include the arbitration provision. But what should they focus on in terms of avoiding the allegation, both as to admin fee, as well as change of rent pricing, as well as the duration of the promotional pricing that many of them put into their websites? How can they get around that?
Well, I think the short answer to that, and for the purposes of this discussion, I think really the answer is transparency. That when you have, for instance, specials or discounts or things like that, that they be clear with respect to the customer who comes on. That you and the other part of this is disclosure. And when if there is a fee that has to be paid in order to rent a storage unit, i.e. the admin fee is the most common, then I think that you have to disclose that, or should disclose it at least, because I think it creates problems. And we're seeing this happen. And I think that the banner or the asterisk with $29.95 admin fee applies to to each of the rentals. There are ways to do this that I think probably overcome most of the problem if you're transparent in your advertising and look at that transaction. I think the most important is, what does the tenant have to pay in order to rent a storage unit?
That's a great point. And I agree completely with you, because from a legal defense point of view, we know that these arguments are out there as each of these states pass these drip pricing laws. And I believe now we have California, Minnesota, and now Colorado recently, and I think others are pending. We have to be vigilant to advise operators to be as transparent as possible, to have these disclosures, these banner references, the information tags that go along with some of the pricing that they can click on, and more information is provided, as well as, and I know people hate this when I do this, but lengthy and complete terms and conditions at the bottom of the website that explain in layman's terms more about the promotional pricing, more about the right to change pricing. These are not static prices. Provisions like you've mentioned concerning arbitration, provisions relating to a myriad of exclusions. I mean, I know in California, this is where we see most often the exclusion that the size advertised may not be the actual size of the unit being rented in the context of a 10 by 10 or a 10 by 20. I mean, right. So isn't that example of like something that has to be on the website?
I think you should, again, you're renting spaces and you use 10 by 10, for instance, but that tells you nothing. And in my mind, because we rent space in 3 dimensions, and nobody ever tells anybody the cubic feet that they're renting. And so I always like to be that you do have something in the rental agreement. I'll probably have it on site that dimension, that size is for comparison purposes only, and is not necessarily the exact measurements of the storage space.
Well, this whole issue with websites, I think, is a fascinating issue, because you can still start talking about the legal liability that goes along with the future world of click wraps and the assent to the contract terms, and how those terms are provided for clarity to the user, to emphasize that they were aware and understood of the terms and conditions before they assented. That's coming down the pike. The world of browse wraps, click wraps, scroll wraps, I think, are all part of the future of online contracting.
Well, you bring up something that's really interesting in my mind, because it sort of brings us back to our days in law school when and your first contracts class, where how you actually entered into a contract was important. And then we spend the next 30 years and no one ever brings that up again in the real world. And now contract formation is a big issue, and especially online contract formation. But we're starting to get, I think, some clarity about it. And the one thing that I do think is important is that there be I don't think you have to use scroll wrap. I think you can use a click wrap system. Almost every circuit that I've seen has accepted that. And that as long as it's clear that the visitor is assenting to the terms of use, and you could have a pop-up box where they basically attend. If I agree to about I accept the terms of use of this website. Click something like that with maybe the link to the terms of use in red or some contrasting color like that. I think that works. But the funny part about it is I've looked at some of the appellate opinions, and the courts look at screenshots. And I find that just fascinating when you're trying to determine if something is good enough.
Yeah, and I think they're leaning towards the enforceability of these contracts. And I think it's fascinating for guys like you and me to recognize that when we uh, go online and agree to some service, whether it be a Netflix or a Amazon purchase, and we click, I agree. And sometimes you and I scroll through these terms and conditions. They're non-negotiable. They're lengthy. They're extremely one-sided. And there's a multitude of exclusionary language in there that if you and if someone was to provide that contract to you in a normal context of a purchase, you'd have at it. There's no way you're going to agree to those terms and conditions, but you're given the choice. I mean, if you don't want to ride that Uber, or you don't want to buy that book, or you don't want to buy that streaming service, I guess you just say no.
And then the wheels of commerce come to a screeching stop if everybody were to do that, and nothing would ever be bought, purchased, or sold.
Well, it's same thing with self-storage. I mean, if someone wants a self-storage unit, if they want to be a customer, they want to use your service, and you provide them terms and conditions. If they don't want to sign it, they can go somewhere else, right?
Yeah, I mean the old paper and ink contract was not something that the typical person who walked in the door read it carefully and then signed it. They said, "This is the size space I think I need. Where do I sign?"
Well, just on this last part, and you and I are talking now, from our contract days in law school, these contracts were never contracts of adhesion, self-storage contracts, because the prospective tenant always had the chance to go, I'm going to go somewhere else. Now, they may have their decision based upon the rental rate as compared to the terms of the offering of the contract. But, if someone chooses to rent there, that's their decision. There's no duress in the contract.
Yeah, and it also didn't really deal with sort of a significant public need like healthcare or housing, or the things where that type of approach to analysis was used.
Well, when was the last time you edited a healthcare waiver given to you at a doctor's office?
They are take it or leave it contracts.
Self-storage. They are. Believe me.
The court scheme to think that healthcare is more important than being able to store your stuff.
Well, the next time you go on a zip line or a hot air balloon ride or a whitewater rafting trip, and you are given the disclaimer to sign away your life, do you sign away your life?
And of course, because you don't really need to do any of those things. There's absolutely, it's totally discretionary. Who cares? There are a lot of people, oh, you want to go on a zip line? Not me.
Okay, I'll remember that the next time I put you in line for a death-defying activity, Carlos.
Okay.
All right, let's talk about Oregon. I know you're excited about this wage theft issue. Tell us what you think is the implication of this Oregon law in the self-storage industry.
Well, it's kind of interesting because quite a number, not a huge, I think there's about 9 or 10 states that have wage theft laws around the country. And a number are looking at the wage theft laws now. And these basically are laws that create liability for employers and penalties who, for whatever reason, don't pay their employees or don't pay them in a timely manner. Oregon has taken a kind of a new step on this, a new approach on this, and they've done it in an area that I think is somewhat significant for self-storage industry. And that is what they have done is they've taken the approach that in a construction project, where you have all of these, you have a general contractor, a landowner, and all of these subcontractors. What they have done is they've basically said that the general contractor and the property owner can be liable for wage theft by the subcontractor. And I know you've dealt with construction projects and had to deal with mechanics liens and things like that. How does this wrinkle? What do you think of this wrinkle?
It's pretty frightening. I mean, it really is pretty frightening. I guess to some degree. I mean, I've always been a proponent of holding on to money owed to others in exchange for appropriate lien waivers, right? Of verification that parties downstream have been paid. If you're finding some of these issues on any of this downstream money concern, you also have the right of making joint check payments to make sure that people are being paid, so that both the contractor and the subcontractor signs off on the check for the check to be deposited. Lien waivers. I mean, you just got to track the money. It is pretty frightening.
Yeah, and I mean, it really puts in a new, you have to have, basically proof that that all the employees have been paid by your subcontractors until you're going to release that final payment.
Yeah, yeah. It only sort of goes to show that it's a little unfortunate, but that the reality of being very wary of the parties that you're contracting with and where the money goes, and being careful. And this, I hate to say, this issue of trust a little bit goes out the window. You've got to be very cautious about how these things work, and you do need to include in your contracts lien waivers, maybe joint check agreements, and just like you said, the provisions in contracts regarding final payment, that final payment will not be issued until there is, again, proof of these payments, appropriate lien waivers signed, and other releases that would seek to indemnify you as the owner from any of these claims. Now, the wage theft thing becomes an issue of potential criminal law as compared to civil law too. So that you can't exclude, potentially criminal issues, but there could be indemnity for attorney's fees incurred in defending against claims.
Yeah. And I think this is interesting because I have a suspicion, that other states are likely to pick this up, because I think, construction is an area where, just because of the way the labor markets work and everything, there are bad actors.
So true. That's unfortunately what keeps you and me employed in this world. Sometimes are the bad actors. Which brings us to the last topic of the day: revenue management and antitrust. Talk about the allegation of bad actors. It's really a very interesting issue because it kind of feeds right back into this whole issue of deceptive trade practicing a little bit and pricing. What's your thought on the algorithmic world of revenue management?
Well, I think we know a couple of things. We know that revenue management software can become the basis of antitrust litigation. And I think for most people, let's keep in mind that we're always, when we see the litigation we're seeing now, basically involving RealPage. I know that it involves Yardy's residential side. We're looking a bit through a rear view mirror, and that there were some distinct errors made in the world of contract law, interestingly enough, Scott. And but there is both private and Department of Justice antitrust litigation against the revenue management software company, RealPage being the largest by far, and also their a number of their clients. But there's one piece of information in this litigation that actually turns out to be quite interesting, and that's Avalon Bay, which is a large property management company, and they've been dismissed from, well, I believe, all of these lawsuits, all of this antitrust litigation. There may be some that's still around, but they were named initially. And the reason they were let out is because they actually read their contract, apparently, with RealPage, and they put a provision in it that their information and they would not share or use private information of other customers in that they're directly in the contract. And again, things that you put in contracts can make a difference. And for them, it made a big difference. And we've had 2 settlements in this area by management companies. And it's not, it's not, these are $billion property management companies, and they're settling with justice for, $2 or $3 million and consent decrees. So it's a serious area. And while it's been focused on residential property, it also it can be applicable to just about any type of business, including self-storage. If you're utilizing your competitor information, private information that gets filtered to you vis-a-vis the software management system you're using.
I think you used the key word there is the word private, is the utilization of private information to develop the revenue management. So it creates an allegation of conspiracy using multiple private sources as compared to the public sources. There's also a unique aspect of that litigation that I thought was fascinating, was the allegation with regard to once the pricing was provided to the users, they were unable to turn it off, meaning they were this higher pricing was basically forced upon them. They didn't have discretion, or there was no real mechanism to reject the pricing recommendation that was issued from the system, and that's where this conspiracy of pricing comes in, because the increased pricing based upon the private information was provided to the user with little opportunity to reject it, and then they would just use it. And that was one of the allegations, I think, with regard to the systems, that it imposed the pricing. It didn't make it optionality. It didn't offer optionality.
That was an allegation, but it was one that was disputed vigorously, I know, by RealPage. I mean, I read one of the things where they were arguing that more than 50% of the recommendations were rejected by their clients. And so there's again, the difference between an allegation and factual proof, because that is a core dispute in this litigation.
What's your thought generally about utilizing the data from rental rates in the area, the location, which surrounds the facility, to create market value rates for your facility? Within the right of the operator to do that?
Generally speaking, you're allowed to use what public information comes your way, except in those it hasn't happened at the state level, but some cities have restricted even the use of non-public, of public information through these algorithms and things like that. And in fact, Berkeley was one of them, but they had to put theirs on pause because they got sued by RealPage. I think one of the things to understand is this is an area where we're, at the earliest stages of the development of the law. And I think, part of the problem was in the very early stages, people, some of the contracts were unfortunate in the way they were written. From a business side of this type of discussion. But I think that there will be growing sophistication, both with businesses that use it, self-storage, hotels use this kind of management software, and residential apartments use this type of software. And the plaintiff's bar. It's always there's always a way to try to figure out how we find the next class action lawsuit or the next antitrust lawsuit.
And that is what worries me most. There's always the goal of finding the next piece of liability, whether it be in the real estate industry or other industries. And I know that self-storage operators are sort of tired of hearing us talk about the minefields that are out there for them. But there is sort of a solution in many ways, is to be educated about these topics, to just like you said, you know, do a review of their websites, do a review of their rental agreements, you know, work with their website developers, work with counsel on their rental agreements and their regulatory compliance, you know, and try to be as transparent as possible about their rates and how they bill for their units and the duration of their promotions. I mean, it's just good business.
Now, and one thing, I mean, it's very important that, you know, no matter what you're doing, is, you know, be wary of if you're, you know, if you have or come in possession of non-public competitor information, because, you know, price fixing is a strict liability. You know, it's not a tort, but it's a strict liability violation. And also, the one thing where the businesses thus far have been pretty lucky is that there's a concept in price fixing called price fixing per se. And if they find that, then there's really no practical defense, because if it isn't per se, which is what we're seeing right now in the litigation area, because the courts have not granted it, you have to show that there is actually competitive damage to the competitive marketplace. And that's a big deal, because that really puts a burden on the plaintiffs in these things. But if you were to engage, if you had written contracts that basically say we're going to share information and use it along the lines to set rates, then you would get that. And that's basically, it's over at that point.
Well, a little scary out there.
Yeah. So be careful, and read that. One thing that, an operator can do that's using, read that contract and read what exactly you're agreeing to when you agree to use their revenue management software. I used to be in the subscription business, and one of the problems, I look at this differently. This thing, the really great thing about the software, utilizing the software and sort of setting trying to come up with rentals, is it's not emotional. And one of the problems in the subscription business, I was in the newsletter business for a long time, was that people were afraid. I mean, publishers were afraid. Well, in real estate, occupancy will go down. My subscriber list will go down. And somebody pointed out to them, you don't care. The only thing you care about is its effect on revenue. And that's a hard thing to do. And I thought that these software systems limited to the emotional care, but apparently they're doing a little more than that as well.
Wow. Good analogy. All right. Well, we're coming to the end of the summer. We're looking forward to the SSA conference in Vegas for the 50th anniversary. Your summer, I know, has been busy with a house renovation, Carlos. Coming to the close of that almost.
Well, we're back in the house.
All right. That's good.
We were out for about 10 weeks. So, so it is. It's coming to a close. And it looks pretty good.
Well, good. Good. And you're looking forward to the Vegas conference?
I am looking forward to the Vegas conference. And I'm a little worried, Scott.
What's that?
Well, at the closing Q&A, there's going to be, 5 lawyers on stage? Maybe 6?
I've heard that. I think it's the Legal Power Hour will be filled with lawyers. It will be interesting if we have topics raised upon which we dispute. So we'll have to get a good audience to see a little pro and con conversation going on, maybe.
Well, I thought with 6 lawyers, that we might have time for one question.
And build at a combined hourly rate of. Wow. Realize how much value they're getting.
That's what I was thinking. The most valuable session that's ever been given at the self-storage.
That is funny. That is funny. We'll have to let the SSA know about the combined billable rate of the lawyers on stage. That's very funny. Well, it's been a joy to do another legal chat with my partner, Carlos Kaslow, the Self-Storage Legal Network. Interesting topics. I think, look, again, I think we're just trying to raise issues that folks should be careful about and learn about, and look at the SSA conference. They can come and be educated and learn more about all these things that are happening in the industry.
Yeah. And we talk about things and the risks that are involved. And I think these are, it's important to understand what's happening out there. But again, you guys have businesses to run, and you're never going to have a perfect solution. And it's a lot more important to have 95% occupancy space than have a perfect compliance.
Good words to live by for a business owner. All right, Carlos, until next time, the next legal chat, we'll and in between, we'll see you in Vegas.
Okay, bye, Scott.
Thank you all for joining us on the legal chat for the Self-Storage Legal Network. We want to thank Lighthouse Storage Solutions for producing this with us with the Self-Storage Legal Network. Again, you can ask questions for us for our future sessions that are going to be on YouTube. We're going to do these 4 times a year at the email below. And certainly you can reach out to Carlos and I via our emails if you have other questions about what we're doing. And certainly you can reach the Self-Storage Legal Network at www.selfstoragelaw.com. Again, thank you.
Thank you.
We'll see you soon.